So this is probably going to be the last thing I go through as far as the ancillary problems of the Owen Hart death. Is that WWE sued Lewmar Incorporated, um, who they say engaged in fraud, collusions, and tortious blankety blank in January 2027, 2003. So we're going to go through this WWE documentary situation, and I'm going to go also through some of the court documents that they have said. We're not going to read them, please. We're not going to read them. We're just going to read what they say happened. So January 27, 2003, World Wrestling Entertainment today said it will vigorously pursue recovering the loss of its settlement in the Owen Hart case from Lewmar Incorporated, the United Kingdom-based manufacturer of the shackle clip, whose premature release led to the accidental death of Owen Hart. Now that a Missouri judge has said a settlement between Lewmar and plaintiff, which is Martha Hart, was invalid because it was not in good faith and was done for an improper purpose. The Honorable Douglas Long, sitting by special appointment of the Missouri Supreme Court, ruled that the settlement between plaintiff and Lewmar for no money was conceived in a fraudulent manner. The judge said that there was overwhelming evidence in the record that the plaintiffs and or plaintiffs' counsel and Lewmar engaged in fraud, collusion, and tortious conduct in negotiating, executing, and seeking approval of Lewmar's settlement with the plaintiff. In other words, Lewmar and Martha Hart was in collusion against the WWF. The WWE announced an $18 million settlement in November 2000 with the plaintiff and then challenged the validity of the Lewmar release. The judge noted that Lewmar had $50 million in insurance coverage for damages arising from Owen Hart's death. The judge said that the failure of the plaintiff's legal firm, Robb and Robb, to recommend the plaintiff demand payment for all of the significant portion of these funds from Lewmar was questionable, and that substantial evidence exists that plaintiff's counsel was motivated by a desire to prevent facts concerning Lewmar's liability for this accident from coming to light in an effort to construct a punitive damages claim against WWE, the judge stated. If the release had been upheld by the court, the settlement between Lewmar and the plaintiff would have prevented WWE from seeking redress against Lewmar for its role in the incident. WWE's attorney, Jerry McDevitt of Kirkpatrick and Lockhart, said the company can now move forward with the case against Lewmar, which is set for trial in September 2003. This order contains some of the strongest judicial statements I've seen in my 22 years of practice against a case which, from the onset, was tainted by irregularities, said McDevitt. First, attempts to manipulate the judicial selection process caused the Missouri Supreme Court to specially appoint Judge Long. Next, we discovered plaintiff and her counsel had entered into a written agreement to share the proceeds of any recovery with fact witnesses in the case. The propriety of that argument was about to be passed upon by the appellate courts of Missouri literally days before plaintiff and her counsel decided to settle the case. When testimony was taken from Lewmar representatives in England, no attempt was made by plaintiff's counsel to establish the factual basis for Lewmar's responsibility. And when we attempted to do so, plaintiff's counsel actually objected to questions proving their liability. As soon as the deposition was over, plaintiff and her counsel announced they had released Lewmar from the case for no money, even though Lewmar had offered to pay money. Now, as a result of Judge Long's ruling, Lewmar will have to face up to his role in this tragedy and all that it did to avoid a decision on the merits. Okay, so this is pretty strong language here, right? The WWE is saying that Martha had intended to share any damages that she got with other people. That's pretty strong fucking language. And if they found evidence for it, that's really sad. That is absolutely incredible. But there's no telling. There's no telling what actually occurred. But this is from the documents. Jackson County, Missouri. Wait a minute. Is this the? Let's see. Okay. Let's see here. What's going on here? Okay, so this is what WWE had to say. This was the relevant information. Lewmar had reason to know its trigger latch snap shackle may be used in such a way to cause harm to a human being, and because of that knowledge, knew of their important need to warn consumers of its danger. Lewmar limited its warnings to mid-Europe and possibly to Hamburg, Germany. Lewmar executives met in 1998 and discussed how to avoid another incident with the trigger latch shackle. For years, Lewmar and its distributors knowingly provided trigger latch shackles for use in the stunt industry. Amspec sold this trigger latch shackle to Bobby Talbert to be used in a wrestling performance, knowing it may be used to suspend a human being above the ground. Even in marine applications, the trigger latch snap shackle may be used to suspend human beings. Then they go into the liability of Amspec, the suspicious circumstances behind the impropriety of the settlement agreements. So let's continue here. Okay, so this is the relevant factual background from the document. It says, in connection with Owen Hart's tragic and accidental death, plaintiffs originally sued, among other defendants, Lewmar and Amspec on June 19, 1999, alleging strict liability and negligence causes of action for defectively designing and manufacturing products which caused or contributed to cause Owen Hart's death, and for improperly warning consumers of the dangers of this product. On March 17, 2000, after 9 months of discovery, plaintiffs filed a first amended petition in which they reasserted the same claims against Lewmar and Amspec. By asserting their claims against Lewmar and Amspec, the first amended petition, plaintiffs certified to this court under the Missouri Rules of Civil Procedure that as of March 17, 2000, their claims against Lewmar Limited, Lewmar Incorporated, and Amspec Incorporated were warranted by existing law, and that their allegations and factual contentions against Lewmar Limited, Lewmar Incorporated, Amspec Incorporated had evidentiary support or were likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. The factual allegations that plaintiffs specifically certified on March 17th, 2000 had evidentiary support include Amspec and Lewmar Limited and Lewmar Marine Incorporated, now known as Lewmar Incorporated, sold, delivered, and distributed such products, including the subject harness system, wherein reference for ultimate sale and or use in the state of Missouri to be used by a foreseeable class of persons of whom Owen Hart was a member. The harness and rigging system and related components then failed, causing Mr. Hart to free fall 78 feet towards the center arena in the wrestling match. The aforesaid harness system and rigging apparatus related component Hart used therein were then in a defective condition, unreasonably dangerous when put to the reasonably anticipated uses for reasonings included but not limited to. Defendant Amspec failed to have a locking snap hook which would have prevented rollout and disengagement of the snap hook. Defendant Amspec failed to have a snap hook size compatible with the member to which it was connected, preventing unintentional disengagement of the snap hook. Defendant Amspec failed to provide a snap hook that was proper for the purpose based on strength testing requirements. Defendant Amspec failed to use a harness system, rigging apparatus, and related component parts that match the particular situation of Owen Hart. Defendant Amspec failed to design a body harness in a manner to distribute fall arrest forces, and defendant Amspec was negligent in further particulars unknown to plaintiffs, but which will become known during the course of discovery. So they have this list of all the things that Amspec, Lewmar didn't do correctly. So the harness system, etc., was then in a defective condition, unreasonably dangerous when put to a reasonably anticipated use. In other words, Lewmar knew that people was using this thing improperly and did not tell anyone, and knew people were using it because they had prior knowledge of people using it properly and didn't tell anyone. They did tell people in Europe, in Germany and all that type of stuff, but they didn't tell anybody in the United States, which the WWF is in the United States, so they didn't know that this and therefore Bobby Talbert couldn't have known that this was not an appropriate thing to use for human beings. Continuing, this is a lot. The aforesaid harness system was used in a manner reasonably anticipated by this defendant and others. Defendant Amspec held themselves out as entities which could carefully and competently design, manufacture, select materials for design, maintenance programs for, inspect, supply, distribute, and sell harness systems, rigging apparatus, and related component parts thereof. The harness system and related component parts designed, manufactured, or sold by defendant Amspec were defective and otherwise flawed, which had the effect of creating a dangerous condition to its users. Defendant Amspec and adequately failed to properly and adequately inform, notify, or warn customers, or users of the defects and of the dangers and effects. Holy shit. As a direct and proximate result of the lack of warning of the dangerous conditions as existed when the harness system was sold by defendant Amspec, Owen Hart was caused to die. In other words, Lewmar knew that people were using these sorts of things, knew that the WWF had bought them, knowing that their product was defective in this way, and Bobby Talbot, not knowing that these materials were not supposed to be used in this way, used these materials and caused Owen Hart's death. Continuing, as will be seen below, the limited discovery taken to date supports many of these allegations. On April 14, 2000, less than 1 month after plaintiffs made these claims against Lewmar and Amspec, plaintiffs executed a dismissal and mutual release with Amspec, in which plaintiffs purportedly released all claims against Amspec for $0. The sole consideration allegedly given by Amspec was, quote, the release and discharge of any and all potential claims or actions for frivolous litigation, sanctions, and the like. Plaintiffs entered an identical agreement with Lewmar for $0. As with Amspec, the alleged consideration given by Lewmar was, quote, the release and discharge of any and all potential claims or actions for frivolous litigation, sanctions, and the like. Plaintiffs' counsel attempted to explain the decision to release the settling defendants. The settling defendants would be the everyone who is sued that was not settling. So WWF and the riggers, Talbot, Alleman, a lot of the other riggers that were involved who were also sued in this lawsuit, Jim Van Zant, a lot of these guys who were in the the police investigation documents, they were also defendants in this case, and they were not settling. Amspec and all those guys were. So as Amspec and Lewmar, they were settling defendants. WWF and the riggers and all those guys were non-settling defendants. Plaintiffs' counsel attempted to explain the decision to release the settling defendants from the lawsuit less than 1 month after plaintiffs reasserted claims against them by representing to this court, the truth of the matter is that a man died for a number of reasons involving negligence, having nothing to do, as it turns out, with the defendants who are seeking to be released. In other words, they're saying that Lewmar had nothing to do with this, whose equipment was totally and improperly used by the WWF, which was discovered upon discovery. Problematically, plaintiff's explanation is at odds with the sworn testimony of the settling defendants themselves and the evidence of record as a whole. And if, in fact, plaintiff's explanation were true, plaintiffs would have had to learn something in the discovery that uncovered between March 17th and April 14th, 2000, from which a reasonable plaintiff would determine that no viable claim existed against Amspec or Lewmar. Moreover, if, in fact, plaintiff's explanation were true, plaintiffs would have had to have learned something between March 17th and April 14th that established plaintiffs' allegations to be so frivolous that rather than recovering against settling defendants, plaintiffs themselves were actually looking seriously at serious risk of paying damages to the settling defendants for filing frivolous claims. In any event, if in fact plaintiffs' explanation were true, plaintiffs would have had to have learned some significant facts since the filing of their suit to compel them to conclude that all of their claims against all of the settling defendants were of zero value. Oh, I hate fucking lawyers. I really do. This is why I didn't become a lawyer, even though I'm pretty good at it. The relevant question, therefore, becomes what critical evidence was uncovered during this 3 to 4 week period, which would lead a reasonable plaintiff acting in good faith to conclude that a release of an alleged claim for frivolous litigation or action sanction constitutes remotely adequate consideration for the release of claims against all the settling defendants. To aid the court in determining whether discovery in this interim period supports plaintiff's contention of good faith, the WWF defendants set forth below a sampling of what was learned about plaintiff's claims against Lewmar and Amspec between March 17th and April 2000. Okay, because this is important, we're going to go through this as well. Okay, Jesus H. Christ. So this is basically what Lewmar knew about the snap shackle, and this is hopefully this is not. I'm not going to find too many more nuggets to dig into because I know you guys are probably listening to this forever. Like, what the fuck is going on? Okay, number one, Lewmar had reason to know its trigger latch snap shackle may be used in a way to cause harm or to a human being, or because of that knowledge knew of an important need to warn consumers of its dangers. Matthew Townsend is the product manager for Hatch and Hardware division of Lewmar Marine Limited, headquartered in Havant, England. He was designed to speak on behalf of Lewmar Limited and on the method and manner of marketing and distributing the trigger latch shackle. Lewmar's battle cry throughout this litigation has been that Lewmar's trigger latch snap shackle has designed for marine use only. However, as Lewmar's own product manager admits, there are 101 applications for that shackle. Only one of them is actually applicable to its design. In fact, the patent application for the trigger latch shackle persists uses in non-marine applications. Despite this knowledge, Lewmar has no policies or procedures in place to ensure the trigger latch shackle is distributed for marine use only. In 1996, Lewmar learned of an incident occurring in Hamburg, Germany, in which one of its shackles was involved. Apparently, a person was injured during a catapult ride. In a catapult ride, two bungee cords are attached to a harness holding a human, and the harness is attached to the ground, stretching the bungee cords. The harness is then released, and the human flies into the air. Following the incident involving the Lewmar shackle, Lewmar was concerned another incident could pose a threat or risk to Lewmar. As a result, Lewmar executives discussed adding to the product various warnings. The number of warnings they considered stretches as long as wide as your imagination can reach. Ultimately, however, no warning was added to the trigger latch shackle. Okay, so as you can see, there was an incident in Germany in which somebody got, flung into the air by this trigger latch thing, and they didn't put any warnings on it. Okay, also because of concern over the Hamburg incident, Lewmar sent letters and telephoned the two Lewmar distributors in the Hamburg area and instructed them not to sell trigger latch shackles outside the marine industry. The letter, dated September 11, 1996, was sent by Hendrik van der Linde, the Mid-Europe subsidiary sales manager. It is unclear at this point in discovery whether the letter went only to the two Hamburg distributors or to all Lewmar Mid-Europe distributors. It is clear that it was not provided to the United States purchasers of this product. Okay, so, it's just more of that. It's just incredibly detailed, granular detail. This is the thing about, lawyers. They go into granular detail. Like, the fact that they even caught this tells you how strong and powerful the WWE lawyers are. Most people would have been trying to get out from up under this and just get over it, but these guys went absolutely into detail. I mean, this is insane. See here, Amspec is in the business of making and selling equipment for the special effects and stunt industry. Amspec sold equipment to stunt rigger Bobby Talbert, including a jerk vest manufactured by Amspec and a trigger latch snackle manufactured by Lewmar. At the time, Amspec sold Bobby Talbert the equipment he used during the May 23, 1999 WWF event. Amspec believed Talbert was working with Elias Edwards and told Talbert the equipment he was purchasing was the same as that used by Ellis Edwards. Not Elias, I'm sorry, Ellis Edwards. So let me read that again with the right words. Amspec believed Bobby Talbert was working with Ellis Edwards and told Talbert that the equipment he was purchasing was the same as that used by Ellis Edwards. Amspec knew Ellis Edwards rigged projects for the wrestling business and that he's flown other people by lowering them to the ring. Holy shit. So I guess Ellis Edwards is the person who works for WCW. Amspec CEO admits that flying is not an unusual part of the stunt activity. Nonetheless, he never informed any customer that they should not use the Lewmar trigger latch shackle to suspend a human being above the ground. Amspec CEO understands trigger latch snap shackles are used in the stunt industry because certain stunts, including some descent type stunts, require the ability to quickly release from something to possibly continue the finale of the stunt. This is, of course, what I was talking about, the Sting situation where you have Sting come down and he's getting into fights and stuff. He has to get out of his rig quickly. Defendant Bobby Talbert has yet to be deposed. Specifically contacted Amspec for the purposes of purchasing the proper and safe equipment for executing the stunt, including descending a human being from great height. Defendant Bobby Talbot expressly related to Amspec information about the specific stunt he was setting up. So basically, Talbot told them what he was doing, and they sold him the materials anyway, even knowing that these were an inappropriate use of their materials. Defendant Bobby Talbot specifically asked for stunt equipment of the exact type used by World Championship Wrestling stunt expert Ellis Edwards. Defendant Bobby Talbot was never warned or advised at any time by Amspec or Lewmar that the stunt equipment he was being sold for the Owen Hart stunt was improper or unsafe in any manner. The stunt equipment Amspec sold to defendant Bobby Talbot specifically included the Lewmar snap shackle that plaintiffs has alleged was improperly designed, unsafe, or otherwise defective. The Lewmar snap shackle sold to defendant Bobby Talbot by Amspec and alleged by plaintiffs to be unsafe, defective, designed, contained no label or warning that it was unsafe for use in stunts, was only designed for marine applications. Amspec and Lewmar never provided defendant Bobby Talbot with any literature or materials containing such warnings. In other words, like I said, Bobby Talbot went to purchase his materials to do the stunt. He said he wanted the same materials that WCW used. They told him this was the same materials. They sold him these materials knowing that people could be injured. They did not warn him. Therefore, they are negligent and therefore liable of this consideration. And Martha Hart found this out and still decided not to sue the companies, but to sue the rigging company, the harness manufacturers, but focus on the WWF. I'm not reading any more of this stuff. So that is a huge part of this. And this is, of course, incredible. But again, like I said, Bobby Talbot is a guy who's got like footprints all over him. But I know this video is long enough as it is. This video is absolutely going to be too long. But there is a concept in the world that is called bounded rationality. And basically what bounded rationality says is that human beings make decisions based off the information that they have. And it is impossible to have perfect information. You're never going to know everything about a decision that you make. You're going to make a decision based on your best information. And if you understand bounded rationality, you understand how Bobby Talbot ended up in this situation. He trusted the manufacturers to sell him the appropriate materials, just like WWE trusted Bobby Talbot to perform the stunt as he told them he had performed it in WCW. So everybody's just making bounded rational decisions, okay? They cannot have perfect information. So this is crazy. Let's continue with the video. In May of 1999, I was 15 years old. I was not watching the WWF pay-per-view at the time. I'm absolutely too poor to order a pay-per-view, especially one that was going to be highlighted by a match that I just kind of knew the finish would be, Steve Austin was going to win. So I wasn't watching the pay-per-view at the time. So how did I hear about Owen Hart dying? I think I saw it on ESPN. I think that I was watching something else, and then I just happened to turn to ESPN, and it was scrolled at the bottom of the screen. And I remember I had a poster on the wall that was it was ripped out of a magazine. It was ripped out of a WWF magazine. It was an Owen Hart with the slammies in the air. I wish I still had it. And I just remember, reading the crawl at the bottom of the screen. And then I went up with an ink pen and I wrote RIP on Owen's chest. And that was it. I didn't know what happened. I didn't really get any details about it. When I eventually watched the event, which was probably months later on tape, obviously you couldn't see anything, but it was a heartbreaking situation. I don't even remember the Raw after Owen Hart died. I don't remember it. I just remember seeing the crawl. I think it was on ESPN when it happened, and writing RIP on Owen's chest on that poster I had on the wall. And Owen was one of the few people I had on the wall. Bret was on the wall, Shawn was on the wall, Undertaker was on the wall, Mankind was on the wall. Honestly, I did not have Steve Austin or The Rock. But it was just a couple of, but those posters that I had, they were ripped out of old WWF magazines, because you have to buy the WWF magazine to get the wrestling card inside. The sheets of wrestling cards. One day I'm going to go through my wrestling card collection, and you will have to buy the magazine to get those cards, just like you have to buy the ice cream bars to get those cards. And I remember I had posters from those days of when I used to buy the magazine when I was a kid. So I had them about 5 years, and I had them taped to the wall. And I hadn't bought any of those posters recently. This is why I didn't have Austin or The Rock or anything like that. I kind of grew out of buying the cards and all that stuff, even though I got right back into it later. But I had Owen Hart because I had a set of Owen Hart cards, and I do still have those cards. I think I have most of them. But I probably don't have everything that I've ever collected. But I do have most of those Owen Hart cards. And I just remember getting up writing RIP on that. And when it comes to me and my memories of Owen Hart, it always comes down to my understanding and the human story of his feud with Bret. Obviously, a lot of people are going to go back to that as being their most favorite Owen Hart situations. It's the feud, the '94 feud with Bret. That spanned about 7 months, maybe even a year. I think it was. I think they were still feuding in 1995. I think they were still feuding in '96, maybe. But it's such a human story, because it was something that I've seen other people deal with, as far as younger brothers constantly comparing themselves to older brothers, and it's a thing that you also see with dads and sons. If there's enough of an age difference between older brothers and younger brothers, you see constantly the attempt to outdo the older brother. Now, you rarely see the physical portion. Like in wrestling, obviously it's exaggerated, where you're going to have Owen physically try to fight Bret. You don't see a lot of that in where I was growing up, but you did see a lot of that competition, that younger brother wanting to prove himself to be just as good or even better than the older brother. And when you go back, as I go back and watch those old matches from time to time, which I do, specifically, the WrestleMania 10 and the SummerSlam 94 match, the cage match, which was, it's an absolute classic, and it didn't involve, anything silly or anything over the top. You kind of look at those things and you say to yourself, like, wow, what an immaculate human story. And it didn't require long, ridiculous promos. It didn't require people being repelled from the goddamn ceiling. It didn't require superheroes or anything like that. It was just a simple story of who's better than who, but with the added blood relation to it. It wasn't a revenge story, or anything like that. But it was all about, hey, Owen wanted to take that next step. He wanted to get out of Bret's shadow. He felt like Bret was holding him down. Bret didn't trust him at the Royal Rumble 1994. He didn't trust him. He didn't tag him in. Like, why didn't you just tag me in, Bret? All you had to do was tag me. And it was like, wow. Even when you go back and watch it today, it's a big, wow. And you could tell that they really got involved in it. And Owen was in the position to improve his stock dramatically. Anybody who could tell you that they remember what Owen Hart was doing, just 2 years prior in 1992, he was really not doing anything. I think he was in a tag team with Coco Beware doing High Energy. I think that's what he was doing in 92 and 93. And he was sort of stuck as that, babyface, nondescript babyface that was doing top rope, high fly and top rope moves. And he was a very fluid performer, but he was very nondescript, no personality. They would say, oh, he's the little brother of Bret the Hitman Hart. And that's all the thing they really had to say about him. They would not really big. They didn't really pump Owen up like that. They didn't really make him seem like he was a big star. And then in early 1994, you kind of felt like Owen Hart was a big star. Like, it was his breakout moment. And it was a breakout moment that was so unique, in so much as you couldn't do it with anyone else. You literally couldn't tell that story that Bret and Owen told. You couldn't even do it with the two other Hart brothers. Okay, and I know that that was one of the stories that was kicked around, was that one of the other Hart brothers was going to be the guy that was going to turn on Bret, but uh, it wouldn't have worked the same. It had to be Owen, and it had to be Owen because Owen was the youngest, and there is something about the reality of that younger brother constantly seeing everyone else, being in the, and I think WrestleMania 10, it had that perfect moment where Owen is in the shadows watching everybody hoist Bret up in the air. That a lot of little brothers, they get that, they see that, and I've heard little brothers say this. Like, I'm not a little brother, I'm the oldest, so I didn't have that experience, but I've been friends with people who are the youngest in their family, and they see that. Like, one of my friends, his brother went to the military, and there was, big hubbub. One of his older brothers went to the military, and it was like this big shindig. Like, wow, you're going to go off to the military. You're going to go be a hero. You're going to go do this, this, and this, and he's just kind of in the corners looking like, really, is that, is that what I need to do, sort of, to get attention around here, to be considered the man, to be considered, is that what's necessary? And it wasn't necessarily true. It's all about your interpretation of events, but you also don't live in that household. And Bret was the shining star of the Hearts, as far as the one guy, the one Hart that made it to the top of the wrestling business. And out of all of them, he was the one guy that made it. So it could only work with Bret and Owen, you know. And to me, that says something when there's a story that is so real and so deep that it can only take place between the two people that it was involved with. And the fact that Owen really kind of took it to the next level as being a snotty, bratty, over the top, egotistical heel, it made perfect sense because, and I like that they really didn't I like that they really didn't end that. Like, it was never really a situation where Bret and Owen sat down and squashed it. It just kind of they naturally moved on from it. Because that's what something that brothers would do, is they would never, sometimes you may have a sit down where there's a hubbub and you share a beer and you have an apology, but most of the time it's just going to be, you're my brother. We have these situations, these circumstances, and we get over them. We fight, we argue, and we get over it. Because ultimately, when it came to the Hart Foundation and that particular portion of the Bret Owen relationship, you saw that they had problems that was beyond the Harts. Like, Bret was at the top of the business at this point. He didn't, Owen was struggling to find himself in the company, in the business at all. And it made natural sense for Owen to have some resentment towards Bret. But now Bret is beefing with literally everybody. He's beefing with an entire country. He's got Shawn Michaels on his ass. Steve Austin is on his ass. And he needs allies. And it's a natural fit for his little brother to come to his aid and say, all right, we may have our differences, but ultimately we belong together. And I think that that's an excellent story to tell over the course of four years. Because I think the Hart Foundation, well 3 years, because Bret was gone in '98. But so from '94 to '97 was the arc of the Owen Hart Bret Hart situation, and I loved it. I thought it was fantastic. And even when I go back and look at their interactions and things today, it still warms my heart, and it actually, makes me very emotional to even talk about Owen, which is, I absolutely did not want to sit through this episode of Dark Side of the Ring. All of the murder stuff, and that's all interesting from a crime perspective. This is not, to me, this is ugly. A lot of the Hart stuff that's been going on since 1999 has been absolutely ugly. And it's really been, for me, it's not about Owen going to the Hall of Fame or not. It's about, I don't like the tug of war that's going on for Owen's legacy. About, who feels that they have a right to control Owen's legacy. Does the fans feel like they have a right to it? Does the Hart family, sans Martha, have a right to it? Does Martha have a right to it? I think that, honestly, if we were to ask Owen, he wouldn't want us arguing over this type of stuff. He wouldn't want all the he certainly wouldn't want Bret and Martha's mudslinging in the newspapers. That shit is so ugly and divisive. And I think that he didn't perform to be, for that. I think that he would want everybody to appreciate him on the same level. And of course his family are going to have a deeper understanding, and his wife has a deep but not as deep situation. Like you can argue all day about whether his wife knew him better than his brothers and all that types of, but none of that is relevant. The important thing is that you wouldn't want to see people that you love and people who love you and appreciate you to be constantly in combat, and that's kind of what it's been for years now. It has been constant back and forth combat over the legacy of Owen Hart. And I think that ultimately we all deserve an opportunity to move on from it. Hopefully this will be, and it probably won't be, but this needs to be the last time this conversation is really had in public. Whatever the outcome of this documentary is, and I'm pretty sure it's probably going to be more Hart mudslinging. It really needs to be that everybody should move on and understand that after 20 years, we need to find common ground. Whether we all just agree that there is no WWE Hall of Fame and forget it, and at least until Martha is gone, or if we all just agree that, maybe one day in the future, or no matter what it is, we need to find some kind of common ground. And I'm okay with any of it, because though I say the WWE Hall of Fame is the best Hall of Fame, because simply there is no other promotions or anyone else that the WWF Hall of Fame is the preeminent Hall of Fame, because nobody else spends the amount of money and time and energy into promoting the careers of professional wrestlers in the WWE. Yes, there are other Hall of Fames, the Meltzer one and the Cauliflower Alley Club and a lot of that stuff. And it's like, yeah, those things exist, but it's different. It's on a much smaller scale. You're talking about here with the WWF. You give these guys one last hurrah. You give them, they get to stand in the middle of the ring, at WrestleMania in front of all of these people and get one last standing ovation. They get to, sit back and tell stories about their career. They get to talk about, they get some of them get documentaries and things like that, where they get a chance to cash in on their own legacies and stuff like that. And you don't have that with anything else. Like, to some people, it's just a list on the website or whatever the case may be. And maybe if that's your opinion of it, fine. But you can't tell me when fucking, I think Ricky Morton got it tattooed on his leg that it didn't mean something. Like you can say the WWE the Hall of Fame doesn't mean anything when it means something, when those guys get to put it on placards and go to Comic-Con and people line up to get autographs. It means something, But if Martha doesn't want that, then respect her wishes. Please respect her wishes. Don't badger her about it. Just hope that maybe in the future other people will change their minds, or just let it go, which is what I did. I let it go a long time ago. For me, the Hall of Fame is important. People will get in on their own time. Rick Rude is also not in the Hall of Fame. Maybe in due time, these things will happen. But if they don't, then guess what? I still have the memories of, being a kid watching Owen Hart. And you can't take those things away from me. You can't, you can't besmudge that with your gossip columns and, your all that mudslinging that's going on. You can't ruin that. When I go back and I watch an Owen Hart match, it is not to remember, how he died or why he died or anything like that. It is to enjoy the match and to enjoy the moment of watching Owen either succeed or hilariously fail. But so I want to end this with a sort of Owen Hart reading list, or if you were a person who didn't watch Owen Hart matches or whatever, what are some of the matches that you need to watch? Obviously, the first two matches that will come to mind would be WrestleMania 10 and SummerSlam 1994, both of which are against Bret Hart. But I think that Owen that Bret would maybe Owen's greatest opponent. The second would probably be Shawn Michaels. They had a match in February 1996 that was tremendous. It was the post-concussion syndrome match where Owen had kicked Shawn in the back of the head, and that was used to write Shawn off TV for a while. And then, they had the return match where Shawn put his Royal Rumble spot on the line against Owen. It was a fabulous match, man. It was badass. The Owen Hart versus the British Bulldog from Raw for the European title, the first ever European title match, is one of the greatest matches in Raw history. It's fucking phenomenal. Okay, it is absolutely tremendous. It is great. The match where Owen actually turned heel, the Quebecers versus the Bret and Owen Hart, was tremendous as well. Beautiful story, fantastic story that was told in that match. You can go back and watch Owen Hart and not be tainted by a lot of the stuff, not be tainted by his death, not be tainted by, all of the stuff that his wife said or didn't say, and all these lawsuits and all that shit. Go back and remember to appreciate Owen and not worry about what other people had to say about him or anything like that. Because that's how I treat all dead wrestlers, with the exception of maybe Chris Benoit. Even to some degree, I can just look at Chris Benoit matches and enjoy them. But when you see a wrestler that is passed on, always remember that their legacy is in what they performed for us, not in what they did outside the ring, even though they may have done great things outside the ring. Their real legacy, as far as wrestling fans are concerned, are what they did in the ring. And we need to, remember that and value that above all else. So like this video, share, subscribe. I know it's been long, but hope you guys enjoyed my deep dive into Owen Hart, and I'll talk to you guys later.